justice, the other justice will become an empty formality. There cannot be any justice without economic justice. Economic justice is the most important thing. That is also what Lenin said. Without economic rights, social rights are virtually is an illusion. That is what was said by another person in a different context. I am talking about Swami Vivekananda. That if you do not give me bread, I don't care for a religion which promises to give me eternal bliss in heaven. Give me bread here. You cannot preach religion to me if I am hungry. So the basic concept, what was said by Nehru, to feed the hungry nation and clothe the naked millions. So this is how the constitution should operate. That is ensured under the fundamental rights, and that is the message, economic message given in the directive principles, which may not be enforced in court, but which is the governing principle of the state. It is stated clearly in Article 37 that in formulation of principle, the state, this is fundamental for the state. All the fundamental rights are fundamental for the freedom of an individual. The directive principles of state policy are fundamental for the governance of the state. So they are casting a duty on the government, on the state, to ensure the civil, political and economic justice for the people. So our constitution is a departure from the British concept of human rights by Locke and John Stuart Mill. They were thinking in terms of civic and political rights. But Indian constitution gives you a lot of economic and social rights. That is the message not only in the preamble and also in the directive principles. And the Supreme Court, in the course of development of our jurisprudence, have read those directive principles into the fundamental rights and made it very clear that both of them are equally important. One cannot be emphasized at the cost of the other. So our basic concept today, basic purpose of discussion today is law to fight injustice. Now, in the law, by law, we mean constitutional law. So the first promise in the constitutional law, the constitution is to promote justice, to ensure justice. How? With these provisions. And there is many articles, like Article 38 of the Constitution, which says the state must strive to promote and usher in a new social order. You see in Article 38. It's a very important article. It is in the directive principles, but it's an article of great importance. The state shall strive to promote the welfare of the people. So therefore, it is a welfare state. By securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. So this is the greatest charter for human rights. State shall strive to promote. What is meant by the state? State includes the judiciary also. What are the three limbs of the state? Yes, ma'am, I am asking you. What are the three limbs of the state? You tell me, you from Kashmir. Tell me, what are the three limbs of the state? You know that. What is executive, legislature and the judiciary. These are the three limbs. So it says state shall strive to promote. That means the judiciary should also strive to promote. This has been commented upon by the judges in the Keshavananda Bharati's case. Take a seat. And of course the executive and the legislature. So each one of them must strive to promote a new and just social order which will vibrate with the same principles in the preamble: social, economic and political justice. So this is the focus, this is the thrust of the Constitution. And as human rights activists and as persons working in different fields, we are clearly just carrying out the constitutional mandate. You may not be state, but you are helping the state. The state is failing to do its duty. But for doing that, on many occasions the human rights activists are persecuted and prosecuted. They are attacked, they are killed. The great case you must have heard, the great decision of the Supreme Court in the Vishaka's case. You know how did it start? The reason, what triggered it? Rape, brutal rape, gang rape of a human rights activist in Rajasthan. And there the Supreme Court came out with various principles and guidelines to protect women in their workplaces. So those of you who are working day in and day out across this region, South Asia, for protection of human rights of the people, you are virtually carrying out the mandate of the Constitution under the Indian Constitution. I think this Indian Constitution is a conglomerate of various ideas on human rights. Because the reason is this, I tell you, when Indian Constitution was being drafted, at the same time, by an accident of history was drafted the Universal Declaration of Human Rights. Both are drafted at the same time. So there is a great resonance of an influence of that Universal Declaration of Human Rights on Indian Constitution. All the articles in the Universal Declaration of Human Rights can be traced under the Indian Constitution. All the articles. It can be traced either in the fundamental right or in the directive principles. They were greatly impacted. So Indian Constitution, the principles are universally accepted. The concepts in the Indian Constitution are universally accepted principles of human rights. I am talking the principles, not the reality. What is happening is a different question. It are universally accepted principles of human rights. So all over this subcontinent and in South Asia, wherever you are working, keeping those principles in mind, you are virtually promoting principles of universal human right. Human right is universal, has to be so. It cannot be confined to a particular area. Because everywhere it is human being, and they are born with these rights. Those who are born with these rights, these are inalienable rights. Those are available to you as of right, not you have to acquire it. And you never think that these rights have been given to you by any constitution. They have been acquired by human struggle for ages. They have been recognized by the constitution and given a place of permanence. And our Supreme Court has said that these rights cannot be altered. That's a contribution of Supreme Court. That these rights cannot be altered, cannot be emasculated, cannot be destroyed. These are permanent rights of mankind. These are rights, which cannot be destroyed, cannot be altered by human effort. This is the structure. And in order to sort of promote this structure, several laws have been made. Several laws have been made. But these, our constitution says that no law can take away or abridge these rights. And our constitution also said that there is a forum which is also a fundamental right to enforce these rights, the Supreme Court. But unfortunately, there is one other provision under the constitution which nobody considers, but the framers have considered. How can you go to Supreme Court each time? Which is in Delhi? Then what will happen? This is very important. How can you go to Supreme Court each time for enforcement of fundamental rights? My proposition reasoning is this, that just by providing fundamental right, Supreme Court has not stopped. The Constitution has not stopped. It has given a remedy of under Article 32. But 32 can be made available only by Supreme Court, Delhi. But how can you go to Supreme Court each time? And has the Constitution made any provision? Yet it has. But that is never done by your Parliament. Nor is there any I am not aware of any discussion in the Parliament or any movement to enforce this part of the Constitution. I am just reading Article 32, Sub-Article 3, which is hardly read by people. Article 32, Sub-Article 3 says, without prejudice to the power conferred on the Supreme Court, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by Supreme Court. Therefore, the framers thought that it cannot be confined to Supreme Court only. Parliament can make law to empower any other court to exercise these powers of Supreme Court. It is not the monopoly of the Supreme Court, but Parliament has never made this law. There has been no demand in the Parliament for making this law. Because today you want decentralization of the justice delivery system. The Constitution has made a provision. You don't have to amend the Constitution. All you have to do is to Parliament make a law to empower these courts to exercise the powers of Article 32. They have not done it. I don't know why there has been no popular movement. You can take up this cause. That it is difficult to go to